Divorce has been a bad word in our country, whether it's a society or the courts. Somehow, the social concept that marriage must be saved at any cost has reflected in our legal and judicial system as well. Getting divorced in India, especially if one of the partner is not consenting, is very tricky, painful, and often very traumatic. But there's a benchmark, there's a landmark judgment that has come from the Supreme Court of India that reads a new ground of cruelty. I'll explain to you about how does that change the dynamics of obtaining a divorce in India, especially if one of the partner is not willing. Usually in cases where one of the partner is not willing, you file a petition before a family court. There are grounds of cruelty that you can invoke. Those grounds need to be proven. It's a long legal battle that is sometimes fought at multiple forums. There are child rights which are involved. There are alimonies or money which is demanded, property rights which are involved. So overall, it becomes a very messy legal affair between two adults who were earlier partners married to each other. Now, because the judicial or the legal process takes its own time, obtaining a divorce sometimes can take decades. We all know of couples that we have seen around, sometimes in our family, in our friend circle, who often get trapped into these vicious legal cycles. Now, the Supreme Court has changed this. 142, the power to do justice, it's a power reserved with the apex court of the country, the top court of the country. Under this power, the court has read that if a marriage has become completely impossible to go on with, irretrievable breakdown of marriage, which means under no circumstance an institution can be saved. Say a couple is living away from each other for more than 6 years, there are various legal issues that are going on between them. The court can exercise a discretion, it can exercise a power, and one of the person within the marriage who wants a divorce immediately can move the court. They can move this application, they can say, look, we want to divorce, this marriage has broken down permanently. Now, this is not a fundamental right that you can go to the court and seek directly. This is a discretion of the court. There are various parameters that have been set, and if those parameters are matched up to, if they are met, only then the court is going to exercise that power. You cannot directly go to the Supreme Court. The entire process still starts from the family court. Now, there are some riders. The first, that this applies only to the Hindu Marriage Act. The Christian Marriage Act, the Islamic Personal Law, they are untouched by it. Secondly, this power is reserved with the apex court of the country. There is no other court that can exercise this power. There's another facet which I want to touch upon, which is that the second motion of divorce, which is the initial period of cooling off 6 months, that can be waived off. This is a judicial position that has existed earlier, and once again the Supreme Court has reiterated. But to put it simply, what does it change? For couples who are involved in this long legal disputes, long battles where one of the partner is unwilling, not giving a divorce, in those scenarios, you can go to the Supreme Court, file a petition and say this is an irretrievable breakdown of a marriage, grant us divorce, and if the court is satisfied under 142, you may get that remedy and you'll be able to move on with your life. Most experts argue that this was a much needed reform in the marriage law space, and because it has happened in the Hindu Marriage Act, most likely the other personal laws will be affected by it as well, going by the reformist tone of the judgments that we have seen. That's a question that is open in the public domain, in the judicial domain for the times to come.